So we're going to go ahead, we're going to move on to Nancy. And Nancy, we're going to start with the basics. So we're going to dig into each of these in more detail shortly, but as a refresher, what are the main legal documents that are strongly recommended for everyone to have in place?
Okay, so I'll try to keep this at 20,000 feet or whatever they say, to keep it basic, but also I want to stress the importance as far as this conversation we're having. So when people think of an estate plan, they, I think, are often thinking of what happens to my stuff when I die, right? And that certainly is a big part of it. And those wishes for what you want to have happen with your stuff are taken care of through usually a will and or a trust. So those are the basic documents for that you may need, at a minimum a will, and then in many cases a trust to make sure that your wishes are carried out for how you want your assets to be distributed. But equally important, and I stress in every single client meeting when we're talking about estate planning, are what I call lifetime documents, which is more relevant to what we've been talking about so far today, which is who is going to take care of making medical or financial decisions for me if I am alive, but unable or unavailable to take care of those things. And that's where we talk about a durable power of attorney and a healthcare power of attorney. The healthcare power of attorney, by the way, you're going to hear all these different terms: patient advocate designation, healthcare power of attorney, advanced directives. These all pertain to the same thing. The healthcare power of attorney or patient advocate designation is the legal document where you are appointing someone to make those decisions. And then, not always, but oftentimes within that, you can indicate what exactly your wishes are. I have kind of come a long way in my development of my healthcare power of attorney document based on my circumstances, not only with my clients, but as well with my own family members. And so I love this vial of life. I've not seen this before. I love that for an emergency situation. Pardon me. But I also have developed something I call quality of life worksheet, and I incorporate that within the patient advocate designation document. And what it is, rather than, many of you have seen or used a document where there's a list of, in this situation, I want this to happen, in this situation, I want this to happen. As I think Caitlin mentioned, or Laura, it's impossible to have an exhaustive list of every situation that might come up. And what I have learned through client experiences and otherwise is that those kind of lists can tend to actually handcuff your patient advocate at a time when they really need to be able to make an important decision for you. And what I mean by that is, if you're suddenly in a situation where your patient advocate needs to make this very important decision, but your situation doesn't fit within these stated scenarios, they don't know what to do. They don't even know if they have the power to make that decision because it's not included there. So my quality of life worksheet is a much more broad, I say it's kind of loosey-goosey, because what it is it's a list of about 15 questions for you to indicate on a scale, a sliding scale, how important things are to you in terms of end of life, things like cost of care, quality of life versus quantity of life, or length of life. So for example, if you give the highest rating to quality of life, quality of life is utmost importance to me, then you go down the list and there's a couple questions about length or quantity of life. Well, you'd probably rate those lower because those are sort of opposites, right? If all you want to do is live as long as possible, regardless of quality of life, well, then you have the opportunity to indicate that. And because it's a sliding scale, I think it's much more helpful. And I have not had a client yet who has not appreciated the opportunity to fill out this form, as well as I've spoken to many of their family members who've said, oh my gosh, this is great, because it gives them that guide. And I know you guys have already mentioned a couple of real life circumstances you've encountered where the kids or whoever is the patient advocate just didn't know what to do. And I think that kind of, whether you use the format that I have or something similar, I just think that is so, so helpful. And I'll be honest with you, I've heard the phrase attorney and counselor. As an attorney, I put these legal documents into place. It can be very boring, but it's very important. But this is where the counselor part comes in. And I just met Caitlin today, but I can tell you Caitlin will be getting a call from me because I love this idea of her facilitating and helping with these conversations. And I stress that to every one of my clients. I'm so happy that you've done this and you've got this document in place. And I do several things to help you communicate that to your family or your advocates. But the communication just cannot be stressed enough. Another thing I wanted to mention that I have as an option in my patient advocate designation document is an opportunity, if my clients would like, to add a provision for consultation with successor patient advocates. So this is the scenario where, for example, I have 3 kids. I do not recommend naming co-patient advocates. You can just imagine what happens. A decision needs to be made right now, and suddenly the kids are fighting over what to do, right? So I always say, you need to have these discussions, figure out who's going to be best, and name that person first, and then you can name your kids as alternates. But then if you want to, you can add a provision that you would prefer, not mandatory, but you would prefer that your patient advocate discuss any of these decisions with your successor patient advocates, or you can say with my spouse and all of my children. What that does is it doesn't handcuff them. It's just you're stating your preference, but not a requirement. But it really encourages that conversation, encourages your family to work together to make this decision. And I feel like those 2 things, the quality of life worksheet and that encouragement for communication, really help support your patient advocate. Because that's really what I've seen is what's needed. It is, again, my job to just help you put that document in place so that that person can act legally. But what I see more and more is it's just so important to have this conversation and help your patient advocate be able to make that decision. Because it is, of course, the hardest thing anyone can ever be called upon to do. And the other thing I just want to add, I know you didn't ask me, but this is a little off topic, but I know that I have talked with many clients who've had the same difficulty that Caitlin mentioned with talking with their kids, talking with their family about these things. I want to tell you, I am in the group now where I have aging parents, my husband's parents are aging, all of our friends' parents are aging, and we are all going through this, what's going to happen if. I truly believe in most cases your kids want you to address these things. They do. They have a hard time talking about it too. It's hard for me to talk to my parents, sit down and say, what do you want to do if this happens? How do you feel about this? That's a hard conversation to have, there's no question. But it is so important, and it's invaluable when the time comes to have that in your back pocket, that you at least know what your parents' wishes are, even if you're going to have to make a very difficult decision.
I feel like the idea of you in the room facilitating that conversation and asking your kids to have that conversation with you is really, really important, because from an adult-child standpoint, I feel like it can be awkward for us to say, hey, by the way, let's have a little conversation. But if the parent brings it up, I do think it makes it, it just opens up that line of conversation in a different way. Now, Nancy, the words will and trust are often used interchangeably, but there are certainly very specific differences between the two. And I know we've covered this in the past here, but can you outline the basic differences of these common legal tools and tell us if there are certain advantages to using one over the other?
Sure. I think at a minimum, you should all have a will. So let me just kind of clarify something that's a very common misconception. You've probably heard about probate, and a lot of people talk about using a trust to avoid probate, but a lot of people don't know what that even means. Why are we avoiding probate? Your group may have been through this. A lot of clients come to me after they've had an experience where they've had a loved one who did not have their documents in place, and they've had to go through a difficult process. So here's what it is. Probate is the court process for administering your estate, okay, your stuff, right? That's kind of the simple form of it. Here's a common misconception. Having a will does not avoid probate. A will provides directions to the court on where you want your stuff to go. If you die without a will and you have assets that are in your estate, then someone will have to be appointed as your personal representative or executor of your estate, and they will have to go through the probate process, and your assets will be distributed, without a will, they'll be distributed according to what's called the intestate laws of the state. And a lot of times, it's exactly what people want. That is, to their spouse and their kids and so forth, and I won't go into detail on that, but it isn't always what you want. And it certainly doesn't take care of anything off track. If you want to do charitable giving, if you have perhaps a child who has extra needs, who you feel you need to provide more for that child, none of that is going to happen if you don't at least have a will that provides instruction for what you want to have happen. Okay, so at a minimum, you should have a will. If you have a will, you will still have to go through the probate process if you have assets in your estate. It's just that the will provides that direction. So why would we want to avoid probate? Well, basically because probate can be a lengthy, costly process. It'll get things done, it's just kind of a pain. And that's where I say if you've ever been through it, that's when people come to me and say, what can we do? I want to avoid this. I don't want my kids to have to go through this. So it's not the end of the world. It's just something that can be avoided, and oftentimes people want to avoid that hassle for their family. One of the ways that we can avoid probate is through use of a trust. And a trust is simply a document that, again, provides direction for what you want to have done, but it also allows us, through funding the trust with your assets, to avoid probate, because those assets that go into your trust are no longer in your estate. Another way that assets can be held, and many of you will have this, are beneficiary designation assets. So your accounts, your IRAs, your bank accounts, those kind of things, you can name beneficiaries. If you do name beneficiaries, which you should, those assets will pass directly to your beneficiaries and avoid probate as well. So it's sort of a big picture using a will, possibly a trust, and making sure those beneficiary designations are in place. Beneficiary designations are not something that I even do, but it's a huge piece of the puzzle of an estate plan, and I always inquire about accounts and so forth to make sure that things are taken care of. A couple more points about a trust. Besides avoiding probate, a trust is private versus a will that is a public document. So again, if that's important to you, I think a trust can be a very good tool. A trust also is, it can be very nice to be a flexible document as circumstances change, or again, if you have special circumstances, if you have minor children, which I don't think anybody in this room does, but if you have any special needs beneficiaries, either children or grandchildren that you want to provide for and do something extra. Special needs is kind of a big one because a lot of times a special needs person will be receiving government benefits, and we want to make sure that if you want to do something for them, you don't want to risk them getting an inheritance that disqualifies them for their benefits. So we can utilize a special needs trust to do that, to supplement their care. Again, charitable giving, things like that. We can just be a lot more detailed and vary our plans with the use of a trust. So it can be a very useful document. It's not necessary in every case, certainly. But I think probably the big one that people talk about is the avoidance of probate for that.
Well, let's talk a little bit about the different types of trusts, because I know that you said some are changeable and I know that some are not changeable. So what are some of the basic types that you see and the difference between revocable versus irrevocable, and why a person would choose one over the other?
Okay, so revocable versus irrevocable. Basically what it sounds like. Revocable is revocable and amendable so long as you are alive and have capacity. Irrevocable is irrevocable. That's it. You've put it in place, can't take it back. And I'll tell you that all of the trusts I do are revocable. That doesn't mean that there's never a reason to do an irrevocable, but it is in most cases unnecessary. So what I do day in, day out are what's called revocable grantor trusts. These are trusts that allow you to have sort of a holding place for your assets with you retain complete control and ownership of your assets. And so, for example, let's say we create a trust and we put your home into your trust. We've avoided probate. We've made sure that however you want your home or the proceeds of your home to be distributed are going to be taken care of through the instructions contained in that trust. But you operate just like you continue to operate the way you do now. That is to say, you still own your home, you still have complete control over your home. If you decide to sell your home, you have complete ability to do that. It doesn't change anything in that regard as far as control and ownership, as well as flexibility. So if you say, in your trust, I want to just distribute my assets equally to my 3 kids, plain and simple. And then next year, something happens. You know, life happens all the time, and it's unpredictable. Something happens, be that an accident or a special needs grandchild is born, whatever the case may be, that changes your thinking on your distribution and what you want to do. You can go back and amend that trust. Very simple amendment in most cases. Once in a while people want to just completely redo, but you can go back and amend that. It's completely flexible, and you don't have to go back and move your assets in or out of the trust. They're already taken care of. You're just doing a simple amendment to that distribution. So it's a very nice tool, very flexible. And it is what most people want and what most people need if they need a trust. When would you possibly do an irrevocable trust? Well, it is, as I said, in most cases, it's just not needed. One reason would be to reduce your estate taxes, get some money out of your estate. I don't, if one of you is in this category, I'd love to meet you. Currently, the estate tax exemption amount, the federal estate tax exemption amount is $13.5 million per person. So if you're a couple, you get twice that for an exemption. What that means is, as long as you are below that level in assets, you do not need to worry about estate taxes. And by the way, Michigan does not have an estate tax. Some states do, Michigan does not. So as far as the federal level, most people do not need to worry about getting these millions out of their estate. If you are in that category, then yes, you should talk to a planner about things that you can do to avoid a pretty big tax hit, but most of us are not in that category. And by the way, that exemption amount is set to sunset in 2026, but it's going down, and that's if Congress doesn't change anything, it's going down to roughly $7 million per person. So still most of us, I'm not in that category. The other reason that people talk about doing an irrevocable trust is asset protection, protecting your assets from the hands of creditors. Yes, that can be done. But again, when people learn what that means, most people don't want it. Because what it means is you are, again, relinquishing control and ownership, really, of your assets. By putting them in an irrevocable trust, you are doing that to give them away so that you don't have those assets, so the creditors can't come after them. That's great, but what if your life circumstances change and you need those assets? You've already given them away. That's the biggest problem that I see, and most people just don't understand that. They hear these buzzwords, right? And the other thing is, most of us don't need that. Most of us aren't in a situation where we have these enormous assets and creditors hounding us, and we have enough to give away so that we can avoid that. It's just not necessary in most cases. So it would be too long of a conversation to get into more detail, but I hope that maybe sets some minds at ease, because I know these buzzwords are thrown around, and like I said, in most cases, that's simply not needed. In most cases, a revocable grantor trust is what you need and what you want.
Gotcha. And as always, I mean, in these presentations, we can only just barely scratch the surface of all these subjects, and that is why our wonderful educational partners are in the room. That's why you get the information on all of our speakers, so that you can follow up at a later date and get your very personal questions answered. So we're going to talk a little bit about power of attorney. So that's defined as the authority to act for another person in specified legal or financial matters. So that's a pretty broad definition. How do you advise clients to the degree of authority that they should grant others, some of the differences in those powers of attorney, and finally, how often should it be reevaluated? And we have about 5 minutes.
Okay,
so
that's okay. Real quick, the difference between the two. A general power of attorney grants broad authority to an agent to act on various matters, but a general power of attorney ends if the principal, that's you appointing this power, if you become incapacitated. That is why I never do a general power of attorney. I always do a durable power of attorney, because what most people want is to have that in place if they become incapacitated. And so a durable power of attorney grants that broad authority, and it continues on if and when you become incapacitated. Okay, so that's that simple difference. As far as a guide on the extent of authority, boy, that's tough. I will say I tend to err on the side of encouraging a broad grant of authority with very careful consideration to who you're giving that to, okay? If clients say to me, well, you know, what if this person's going to do this or this or this, then I say, well, I'd be thinking twice about that person if you already have those concerns. And I really mean that. I don't mean that in jest, but secondly, there are a couple things that you can do. You can make your power of attorney immediately effective, and a lot of people, most people I would say, like to do that because then it's just seamless. But you can also make it a springing power of attorney that it's only effective upon your disability. The issue with that is simply that then your power of attorney will have to go through getting 2 doctors to sign off that you are truly incapacitated. And a lot of times it's those in-between situations, particularly with spouses, where they want to be able to act right away. And so we can do an immediate grant of that authority if you're comfortable with it. And then there's a whole scope and range that you could do for limited power of attorney. Those are more on a case-by-case basis, I would say. I think it's most important to consider having some document in place because, and by the way, I think we'll touch on this real quick at the end here, but your agent has a fiduciary responsibility to act for you in your best wishes. That is so important to remember. They're acting on your behalf. So you are as broad authority as you can give them. You are not giving them the authority to just take your assets and run. Absolutely not.
And one last thing that I'm going to move on to Joel because we're getting short on time. But one thing I just want to mention because it's something that I deal with all the time is when we've got power of attorney, let's say just of our parents, and then that parent passes, that power of attorney does die with the individual.
Yes.
So that's something that not everybody realizes. If someone's passed and they want to sell the estate, for instance, and they say, well, I've got power of attorney, that is not, that means nothing. It's not worth the paper it's printed on. The moment that person passes, there must be other legal documents that then take the place that are already in place so that something can
Correct,
happen.
and thank you for mentioning that, Laura. If you say have a power of attorney in place who is helping with, paying your bills and has access to your bank account through their power of attorney, you're absolutely correct. The minute you die, that ceases to exist, that power. So that's why it's part of an overall estate plan and making sure that all the documents are in place so that things are seamless, whether you're alive and incapacitated or have passed on.